This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what a staged accident is, and it is one where claimed collision was intentional and why evidence is needed to use a staged accident claim as a defense to a suit. Because staged collisions are always intentional, fraudulent acts. In State Farm Fire and Casualty versus Felix A. Quinones et al., the New York Supreme Court of New York County on March 7, 2025, found that State Farm sought to disclaim coverage for medical treatment provided to the defendants who were involved in an automobile collision on February 26, 2020. The court granted the plaintiff's motion for summary judgment in part, citing that State Farm has no obligation to pay claims submitted by Grand Medical Supply Corp due to Quinones' failure to appear for examinations under oath. However, the court denied the plaintiff's motion for summary judgment on the basis that the collision was staged, stating that the court found that State Farm had produced insufficient evidence for a summary judgment. In this declaratory judgment action, plaintiff sought to disclaim coverage for medical treatment provided to defendants Felix A. Quinones, Miguel Burgos, and Kevin Gonzalez by the other defendants, all medical providers for injuries for Quinones, Burgos, and Gonzalez allegedly sustained in an automobile collision on February 26, 2020, involving a car owned and operated by Quinones in which Burgos and Gonzalez were passengers. Burgos and Gonzalez appeared at examination under oath and testified in pertinent part that they were traveling to a Sonic restaurant for dinner and that the subject collision occurred on a highway, the name of which they did not know, when Quinones' car was hit hard from behind, leaving a big dent in the bumper of Quinones' car. Plaintiff moved for summary judgment on the grounds that 1, it had established the subject automobile collision was staged, and 2, Quinones failed to appear for examination under oath on July 2, 2020, August 18, 2020, and October 27, 2020, thereby breaching a condition preceding to coverage under his policy with the plaintiff. In support of its motion, plaintiff submitted an affidavit by claim specialist Dominique Wafer, transcripts from the EUOs of Burgos and Gonzalez, the certified police report, and amended police report from the subject collision, and the declarations page of Quinones' insurance policy with the plaintiff. In her affidavit, Wafer states that the plaintiff's investigation of the subject claim uncovered evidence that the alleged accident involving Felix Quinones and his 2015 Hyundai Veloster occurred on February 26, 2020, just 2 days after Mr. Quinones insured the vehicle with State Farm. The court granted the plaintiff's motion for summary judgment in part, declaring that State Farm has no obligation to pay claims submitted by Grand Medical Supply due to the fact that Quinones refused or failed to appear for his EUO. The court denied the plaintiff's motion for summary judgment on the basis that the collision was staged. The court concluded that there was insufficient evidence to establish the accident was staged. The court noted that while an intentional and staged collision caused in the furtherance of an insurance fraud scheme is not a covered accident under a policy of insurance, the plaintiff had not established the subject collision was staged. Specifically, the court found that the evidence relied upon wafers such as accurate reports, Carfax reports, and information from other vehicles' event data recorder were inadmissible hearsay. Additionally, although the EUO transcripts referenced by Wafer were admissible, the purported inconsistencies and inaccuracies in these transcripts raised serious credibility issues, but ultimately did not pertain to the nature of the collision itself. so as to meet the heavy burden required to obtain summary judgment. In my opinion, insurance companies are faced with insurance fraud and claims from staged accidents on a regular basis. The insurers and their investigators are compelled by law to conduct a full and thorough investigation by its claims or special fraud investigative unit. In this case, there were many elements of a staged accident produced in the motion for summary judgment, but the court was not convinced on a summary judgment motion that the insurer proved the accident was staged. Every insurer faced with this type of attempted fraud must do a thorough investigation and produce convincing evidence that the accident was staged, recognizing that all of the available red flags exist, but that is not evidence of a staged or fraudulent accident. They need real admissible evidence, which they will produce at trial. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 5,000 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a small fee subscribing to my Substack publication. Thank you for your attention.